Hi, I wanted to do a quick update for you on recording people without their knowledge. I've done an earlier video and you can click on that to learn more about that. But first let me tell you that a new case came out about recording people. The first thing that I think you should know is that the law in Texas is still clear. You can record somebody without their permission as long as you're part of the conversation. Again, I give the caveat that before you do it, you might want to talk to a lawyer. There may be some circumstances where you can't do it, but that is the general rule, that you can record people without their permission as long as you're a part of the conversation. In other words, you're involved in the conversation. You're involved in being the one being spoken to, then you can legally record that. The court reaffirmed that in a case called Long versus State. But the case is really more interesting because it shows the danger of intercepting conversations between two people. And we always kind of think about wiretapping as the way to intercept conversations, but that's really pretty rare. The way most people do it is they take their phone, they put it on record, and they leave it in a room, put it in a room, and they leave. In this case of Long versus State that came out last year, I think is really important and instructive for everybody to understand about how to deal with these types of situations. Let me tell you what happened in this case. In this case, and I'll just kind of summarize it quickly, there was basically a woman who got her child. And so that's the little bit of distinction, although I don't think it would matter if it was her or her child. She got somebody else, her child, to go in and record a halftime, I guess a pep talk between a coach and the players. Now, the child was not part of the team. The child had to actually come up with some lies to get in the locker room to put her iPhone in so she could record the conversations. So she went in and she turned on the conversations and she left. She came back, she got the recording, she gave it to her mother, and her mother sent the recording to some people. Anyway, the coach was upset. He went to the police and the police arrested this woman. They charged her with a second-degree felony, which basically is intercepting a communication, and she was convicted of a second-degree felony. Well, she appealed the case, and her arguments were really, I thought were pretty good arguments. Her argument was that you can generally record people as long as they have no expectation of privacy. And she cited a couple of cases saying that in the classroom, teachers don't have an expectation of privacy. The court, it's a very long case, but at the end of the day, the highest court in Texas for criminal cases stated that the coach did have an expectation of privacy, and I suppose the players in there too, and that intercepting these communications was illegal. The case is a little bit concerning to me because I have a hard time understanding how a coach talking to a bunch of children should ever have an expectation of privacy, but that's what the court said. And you've got to know that there was a prior case where two basically people that were arrested were put in a cell and they were recorded. And they said, hey, we had an expectation of privacy in that one when we were recorded. And the court said, no, society doesn't want people in jails to have expectations of privacy. So therefore, you had no expectation of privacy. The court basically said you have to feel that you had an expectation of privacy, but it must be reasonable, and that wasn't reasonable. But again, in this case, they said, no, it was reasonable. There was an expectation. There was an expectation of privacy. So what I really think it comes down to is recording people that when you're not part of the conversation is very, very risky. Now, I will tell you that from my perspective, I'm an employment lawyer in El Paso, Texas, as most of you know. And the interesting thing for me is that lots of employers have in their handbook, you should have no expectation of privacy in the workforce. And so I suppose if somebody recorded a conversation between two other people in the workplace, if their handbook said there's no expectation of privacy in the workplace, if it said that, they might could try to use that as a defense, but I think that would be extremely dangerous. I would never, ever advise anybody to do it. So I still think the general rule should stand for the proposition that you don't record two people, when you're not a part of that conversation. Do not intercept conversations. It's very risky, and the downside is huge. It's a second-degree felony. It's one of those things that will ruin your life. So proceed at your own risk if you want to do that. my advice would be to never do that. Thank you.